A federal appeals court in New Orleans, composed of conservative justices, heard arguments Wednesday over the legal status of the widely used abortion pill mifepristone. The hearing featured sharp questions and interruptions from the judges almost as soon as it started. When the Justice Department attorney described the case seeking to revoke the FDA's decades-old approval of the drug as unprecedented, Judge James Ho quickly interrupted, saying, "I hate to cut you off so early, but you just said unprecedented. We had a challenge to the FDA just yesterday." This all comes after last month, a federal judge in Texas suspended the FDA's approval of the abortion pill. The ruling was then blocked by the Supreme Court, allowing the pill to stay on the market, but with some restrictions. To help us understand all of this and what to make of today's hearing, I am joined by Elizabeth Wydra. She's president of the Constitutional Accountability Center, a nonprofit law firm and think tank. Elizabeth, let's start with the judge's questioning. What did you make of it?
Yes, the judges did appear very skeptical of the FDA's argument that the doctors and anti-abortion groups that have brought this lawsuit have not suffered any actual injury by having mifepristone on the market. They do not prescribe mifepristone. They do not intend to prescribe the drug. And they also seemed skeptical, frankly, of the reality surrounding mifepristone. It's been on the market for more than 2 decades. More than 5 million Americans have used it for medication abortion. But the judges today seemed resistant to hear those facts from the FDA's lawyer. And they seemed much more inclined to perhaps revoke the FDA approval of mifepristone, which would not only have an enormous effect on the way that Americans in every state across the country access abortion, but also could have serious impacts for FDA approval of other drugs and impact drug development and medical research and innovation.
Elizabeth, was it your sense that they disputed those facts of standing and of the long record of FDA approval of this because they believed the facts were otherwise, or they just thought those were immaterial to what's before them?
Well, it's a little bit unclear, of course. We'll know more when we get the actual written ruling from the court, which they don't have any particular deadline, so it'll probably take a little bit of time for them to write that. But certainly these are conservative judges. There were 2 Trump appointees, 1 George W. Bush appointee, and certainly I think that ideology comes into play here when it comes to abortion rights. But it is truly an unprecedented decision to second-guess the FDA's scientific expertise here in deciding that a drug is safe and efficacious for the market. There was definitely that initial reluctance from Judge Ho to say that was unprecedented, but it really is to have inject into the FDA drug approval process non-expert judges and perhaps politics. And that's certainly not how I think Americans of all ideological stripes want their drugs to be determined, whether they're safe or not, and whether they can access them or not.
Can you help us understand why the Comstock Act of 1873 is crucial to this case?
Yes, so the Comstock Act is a law that many legal experts consider to be out of date. It prohibits things being mailed with the intent to produce abortion. It has been interpreted to have very little impact. And to the extent it is applicable in any circumstances, it has been understood to apply only where there is an intent to produce an unlawful abortion. So that's really important here. As we know, medication abortion remains lawful across the country in many states. And certainly the FDA has never been required to take the Comstock Act into account. It doesn't appear to be binding on the FDA. They're concerned about safety and efficacy of drugs. It would apply to perhaps the U.S. Postal Service, which would make sure that these contraband items are not being sent through the mail to the extent they are considered illegal. But that is not really part of the FDA approval process, nor should it be. And so it was unclear exactly how that would come into play, but that would also be an extraordinary new reading of the law that would seem to be perhaps motivated more by opposition to abortion itself than an actual proper reading of the Comstock Act.
And finally, Elizabeth, can you help us understand how the ball's going to bounce here? There have been rulings, blocked rulings, and so forth. The Supreme Court blocked the lower court's ruling that limits access to the pill, but the Supreme Court order will remain in place, right, no matter what the outcome of the hearing. So mifepristone will still be available. So what can we expect in terms of a timeline?
Yeah, I think that's important to note. For half of all abortions in America are performed through medication abortion. So it is important for people to know that because of the Supreme Court's order, it will be available until the Supreme Court rules, regardless of what the Fifth Circuit does here. It'll probably be next term when the Supreme Court takes this up. That would be the term that would start in October. We're still wrapping up the one that we're in right now. But I think that, the Supreme Court will be thinking about the implications across the board for FDA approval of all drugs, for the impact on the pharmaceutical industry as a whole. And while we've seen the court being willing to overturn Roe versus Wade and restrict abortion rights for people in this country, I think even for this conservative court to completely upend the FDA approval process and the drug development market in this country, I think that is a whole other step for them to take that they're going to be very reluctant to do.
Elizabeth Wydra, president of the Constitutional Accountability Project. Thank you so much for being with us.
Thanks for having me.